and I am speaking in opposition of the House bills relating to strengthening the penalties for assault. Our concern here is not to argue that assault on a police officer is ever acceptable or appropriate, or that serious injury on a police officer is anything other than horrifying. Our concern here is more than anything regarding equal protection of the law. We are aware that charges for assault, especially at public protests, are frequent and often occur in the context of the dispersal of crowds. There have been a number of cases that we have encountered where protesters have been charged with assault for involuntary contact with police officers that has not resulted in any injury, and where those charges have been dropped after a deal of legal trouble but before they got to trial. We're concerned that strengthening these penalties will increase the leverage of authorities in plea bargaining situations, and that will result in more instances of abusive suppression of protests going unpunished. We would like to see a more comprehensive reaction from the legislature that deals with the threats to the legitimate threats to police officers' safety, and that deals with the problems of abuse of members of the public. But these are not those bills, and several measures for police accountability that are worthy measures have been shelved this session, so this should not come through outside of the regular order and be rushed through into law.
That the individual who had shot and killed Officer Tarantino Jr. had a number of run-ins with police. He was known to police, and on several occasions was known because he assaulted police. This brought to light a disparity in the law as it is today, that assault and battery with bodily injury or seriously bodily injury on a police officer is only a misdemeanor. We need to update our law. We're not looking to create a brand new one. Just update it, modify it, so that if you commit assault and battery with seriously bodily injury, that you are susceptible to facing a felony charge and potentially a felony conviction. I also want to mention that I support and appreciate the voice and the leadership of Governor Baker, Lieutenant Governor Polito, and Secretary Bennett for drafting their own version and filing it, and you're hearing that as well today. And I would support their version over our version, or vice versa. It doesn't matter to me. If your committee is willing to report something out favorably and move it through the legislative process to the next step, I'm all for it. What happens if somebody who is drunk at a bar, has to be removed and gives an officer a hard time and pushes them away or something? That's still going to be a misdemeanor. Okay? We're not looking to make assault on a police officer a felony. It has to be assault, it has to be battery, and it has to be with bodily injury or seriously bodily injury. It has to reach all of those components. And if we can't do that for our police who are out there each and every day, who are out on a street at 12:30 in the morning, that's so quiet. I mean, like I said, I live on that street. It's so quiet. To go out there, and we can't do something a little bit extra to maybe keep one of those individuals in jail or put them in jail. Because not only are they a threat to police officers, but they are a threat to the general public.
The first part of the bill is just to place ABPO among the things that we allow the DAs to file for dangerousness. And I think that that's just a good thing to allow ABPO to be part of that. But the second thing, which I think is the more controversial thing, is whether or not we consider assault and battery police officer with serious bodily injury to be a minimum mandatory charge, and whether we consider it also to be a felony. I think the fear on some people's part is that this will involve a shove or a push, or that it will be used as a sword rather than a shield against the public by an overzealous prosecutor. And I've been a defense attorney, and I've been a prosecutor, and I understand why there's a fear of that. But there's a safeguard there, and that's serious bodily injury. The police officer would have to have their bodily function of their face or their arm or their hand or their ability to walk damaged. No one could use this as a sword against a defendant. It would always be a shield. Now, a great legal mind who's a legislator said in a recent hearing, let's not talk in possibilities. There's always possibilities. Let's talk in probabilities. Okay? So let's talk in probabilities. It is probable that when an individual picks up a weapon, they're going to have to consider what the results of using that weapon is. Now, if they're going against a police officer and that weapon could cause a significant enough damage that that individual, that police officer is going to be damaged enough that it's going to cause their bodily functions to be impacted, their ability to walk or their face will be damaged in that way, they may not use it if they know for sure they're going to jail, as opposed that they could get probation or some lesser sentence. And I think that will help protect our officers. And that probability that it will help protect our officers is something that I'd ask you to consider. Because a probability that protects the people that we're asking to provide a special function in our society, I think is a good way to help the officers. And that's what this is about. Let's help to protect the officers. It's no guarantee. You can't write a law that's going to help everybody out there. But I think it's a good step in the right direction for serious bodily injury to police officers. And that's really what I came to testify about.
And to the members of the committee, my name is Rasan Hall. I am the director of the Racial Justice Program for the American Civil Liberties Union of Massachusetts, the ACLU. I have also had the privilege and honor to serve as an assistant district attorney in Suffolk County, and I served with honor in that role for 8.5 years. And had the honor and privilege of working with some of Boston Police's best, as well as Massachusetts State Police. I have relationships with police officers, and I take the role that they have and the work that they do very seriously. One of the more memorable cases that I handled was the case of an individual named Richard Clausen, who shot a police officer, a Dedham police officer named Sergeant Mike Buckley in Roslindale. That individual was prosecuted and now serving a 40-year sentence. And I say that to make the point that there are adequate protections already. In regards to some of the protections that already exist, there is already a penalty for assault and battery with serious bodily injury. There is already a penalty for assault and battery with the use of a dangerous weapon. There is already a penalty for assault with intent to murder, and there is already a penalty for murder. Any of these proposed bills would not have prevented the horrible tragedy that happened to Officer Tarantino or any other officer that has lost their lives in the line of duty. The notion that there is a deterrent effect by making it either a 5-year sentence or a 10-year sentence or creating a mandatory minimum, the reality is that the individuals that end up being charged with assault and battery on a police officer are not taking the time to think about what the potential penalties they may face will. This bill is about retribution and punishment. And as a society that has been suffering from retribution and punishment in the criminal justice system that has played out in racially disparate ways, we need to really consider the bill that is before us. There has been a significant decline in assaults on police officers. This in no way minimizes what we have seen in the tragedies that have occurred when officers have lost their lives. But we need to be honest about the narrative around what we are trying to do and why we are trying to protect our police officers. Our efforts should be directed towards transparency, accountability, restorative justice, and healing.